Hi, I'm Bill Kirshner, an Assistant General Counsel with the FLRA's Office of the General Counsel. In this series of videos, the Office of the General Counsel is providing training on collective bargaining, one of the most complex subjects under the Federal Service Labor Management Relations Statute. This series will cover what is included in the scope of bargaining, what represents good and bad faith bargaining, duty to bargain issues, including term, midterm, and an in-depth analysis into change bargaining, addressing both what is a change and what impact is necessary to support the finding of a bargaining obligation. What defenses exist that may modify the duty to bargain, including covered by, contract interpretation, and times when grievances not ULP should be pursued. And lastly, remedies when bargaining violations occur. You will soon see that collective bargaining is one of the most complex subjects under the statute. If you do not watch the entire series, you may miss critical information affecting your ability to bargain successfully. Why is bargaining so complex? It's complex because there are three broad factors simultaneously at play in bargaining cases: scope of bargaining, duty to bargain, and defenses to the duty to bargain. Let's explain what each of these mean. First, scope of bargaining addresses what topics are generally included or excluded in the matters a union may be entitled and an agency may be required to bargain. Second, duty to bargain sets out when the duty to bargain arises. Generally, this encompasses term, midterm, and change bargaining. Third, defenses to the duty to bargain need to be examined. Sometimes it appears a matter is within the scope and duty to bargain, but for one of several legal reasons, the union does not have a right and the agency does not have a statutory duty to bargain. This video addresses what remedies are available when an unfair labor practice related to collective bargaining is found, meaning when bargaining falls within the green shaded area and a party fails to bargain as required by the statute. This series introduces terms and concepts the OGC will raise in investigations which help govern the FLRA in adjudicating bargaining disputes. It does not represent legal advice. Now, on to the presentation. The statute describes the powers of the Federal Labor Relations Authority to remedy unfair labor practices, which include ordering an agency or union to cease and desist from committing unfair labor practices, renegotiate a collective bargaining agreement, and possibly give the new terms retroactive effect, reinstate employees with back pay when appropriate, and take other actions that will carry out the purposes of the statute. Because the FLRA may order unions and employers to take other actions to carry out the statute's purposes, the FLRA has broad discretion when crafting appropriate remedies. When crafting remedies, the FLRA attempts to recreate, to the extent possible, the conditions that would have existed had a party not violated the statute, and deter future misconduct. However, remedies may not be punitive, meaning the Office of the General Counsel will not seek to discipline individuals, and remedies may not conflict with other laws. Standard traditional remedies are applied to almost every unfair labor practice, including bargaining violations. These include cease and desist orders and the posting of a notice to all employees. Notice postings traditionally include physical notices and electronic ones when charged parties customarily communicate electronically with employees. The importance of notices cannot be overstated. They represent the most efficient manner in which employees learn of their rights, learn of violations, and learn that the FLRA is enforcing the statute. Notices and bargaining orders can be tailored to fit individual case circumstances. Remedies may apply equally to either federal agencies or unions, depending on which committed a bad faith bargaining unfair labor practice. Thus, either party can be ordered to bargain in good faith, to bargain at reasonable times and places, and to avoid unnecessary delays, and to be represented by duly authorized agents who approach negotiations with a sincere resolve to reach agreement. Agencies, rather than unions, most frequently commit unfair labor practices related to unilaterally implementing changes in conditions of employment. In these circumstances, the authority may order the change be reversed and returned to the status quo ante. This status quo ante remedy encourages agencies to fulfill their bargaining obligations before implementing changes. Status quo ante means a return to the previous state of affairs by undoing the change and returning to the prior practice or condition of employment. This means once the condition is restored to the way it was before the change was unlawfully implemented, a party is free to propose the change and then bargain to agreement or impasse. Once notice of a proposed change is given, absent exigent circumstances, the parties must maintain the status quo throughout the bargaining process until agreement is reached or any impasse is resolved. We will discuss the legal test for imposing a status quo ante remedy after we first discuss other authority options. Another alternative results in the authority ordering post-implementation bargaining, meaning the change is allowed to remain in place, but often the terms agreed upon in later negotiations are applied retroactively. And what about remedies requiring that monetary damages be paid? There is a legal theory called sovereign immunity. It comes to us from ancient common law and meant then that the sovereign, the king or queen, were the law, were not subject to the law, and could not be found liable for damages unless they consented. This concept comes from the past, but today it means our government is immune unless it consents to being sued. The Back Pay Act waives sovereign immunity and sometimes allows for monetary remedies. Indeed, the Back Pay Act expressly authorizes, in certain circumstances, compensation in the form of back pay and other related differentials when supported by the underlying claim and facts. Now, as promised, let's examine the legal basis for status quo ante remedies. Looking back at our scope of bargaining chart, for matters that are substantively negotiable, shown in green, the appropriate remedy, absent special circumstances, is a return to the status quo ante. For example, if unit employees were unilaterally denied access to parking spaces they previously used as a condition of employment, that prior access can be returned. If the parking spaces were destroyed, new spaces can be added, depending on the remedy ordered and the ability of the parties to reach an agreement. Now looking at the yellow section relating to management rights, where the union's right to bargain is appropriate arrangements and procedures, a stricter test is applied to determine if a status quo ante remedy is warranted. The authority's lead case is Federal Correctional Institution. It established factors that are considered when determining the appropriateness of a status quo ante remedy. These include whether and when the agency notified the union concerning the change, whether and when the union requested bargaining, the willfulness of the agency's conduct in failing to bargain, the nature and extent of the impact on adversely affected employees, and whether and to what extent a status quo ante remedy would disrupt the agency's operations. A discussion of the authority's application of the FCI factors can be found in the OGC's ULP case law guide, found here. An additional idea to consider about bargaining remedies. The authority, the Office of Administrative Law Judges, and the Office of the General Counsel can require parties to return to the bargaining table to negotiate. Only one component at the FLRA, the Federal Service Impasses Panel, has the authority to impose conditions of employment. Said another way, the authority, its judges, and the OGC can order a return to the status quo ante, which includes the agency rescinding the change and returning the parties to the bargaining table to bargain to agreement before implementation. But they cannot dictate the agreement's final terms. When a status quo ante remedy is not appropriate, respondents can also be ordered to bargain and apply agreements retroactively, or be ordered to engage in solely prospective bargaining with new agreements only applicable in the future. This concludes the video describing remedies for unfair labor practice charges addressing bargaining violations and the collective bargaining series. For more information, visit us online. And as always, feel free to contact the FLRA for assistance.